KJ, good afternoon. Thank you for joining us. We're here to talk about the Caribbean Court of Justice, also known as the CCJ, granting orders just today regarding the extradition hearing with the Mohammeds. First off, I'm going to ask you for your comments on this.
So thank you very much. As you are aware, and no doubt your viewers are aware, the Mohammeds made an application to the CCJ seeking special leave of that court to appeal a decision of the Guyana Court of Appeal. In their application for special leave, they also included an application for a stay of the magistrate's court proceedings. The CCJ is a final court, and it is Guyana's final court. Final courts approach cases in a particular way. So today you had what is called a case management conference, where first of all the court sounded out from everybody what their respective positions were. So the applicants' positions were that they want leave to appeal and they want a stay to be granted while their application is pending before the court. The respondents' position were that we are opposed to the application for the stay, and we would necessarily be opposed to the application for leave to appeal as well. We take such a position because we are of the firm view that the appeal will not succeed, that the appeal has no likelihood of success, and we respectfully maintain that position. In the face of that position, we necessarily have to oppose the application for the stay. Though we pointed out that a stay may not even be necessary because we believe that the appeal, because it doesn't raise any great complex issues of law, will be disposed of even before the committal proceedings are concluded, having regard to the pace at which those proceedings are moving. Nevertheless, the court in this case management conference, as a case management order, said that they will direct a stay of the magistrate court proceedings until they dispose of the case before them. And that is the normal position that final courts take across the globe, because this is the final court. Final courts must make decisions that ensure they enjoy the confidence of all sides. Significantly, the court emphasized a couple of things. One, that there is a public interest that the court must take into account in all its decision making. Secondly, that the court is dealing with extradition proceedings, which is a peculiar type of proceedings. Thirdly, that extradition proceedings must be treated with dispatch. Now, those are important pronouncements. Thirdly, I highlighted to the court the way courts across the globe have dealt with challenges to committal hearings being carried out in other courts and being protracted. And it is in that context the court emphasized the need to treat this case with dispatch And I believe the court then decided to give directions of an aggressive nature. I think that's how the court used the term, an aggressive list of directions. So each side were granted leave to put their respective submissions in writing in very abbreviated periods. And the appeal itself has been fixed for hearing on the 21st. Speaking times have been allocated already for each side and each lawyer who is scheduled to speak. So to preserve the status quo, to preserve the integrity of the proceedings that are pending before the court, a final court would normally preserve the status quo while the appeal is being heard. And that is precisely what the CCJ did. It did as we expected it to do, to preserve the status quo until it hears and determines the appeal. But the important thing that I want to emphasize is that the court repeatedly stressed the urgency of this matter and the need for it to be concluded with dispatch. And I am hoping that those sentiments coming from the highest court will transmit lower down the judicial rung of the ladder, so that courts who are dealing with the matter can get a clear signal that the highest court is saying that the matter must be dealt with dispatch and speed, because the public interest dictates that, the policy of the law of extradition dictates that. And I am happy that those issues were made clear. The 21st is not a long time from now. It's just, less than a month. The case in the magistrate court was adjourned in any event until the 12th of April, I think. So essentially is an extra 8 or 9 days. But a major plank of the challenge would be disposed of on that date. I see all type of irresponsible postings are being made on Facebook. And I just wish to, I don't want to curb anybody's enthusiasm, but simply to say that the appeal will be determined, and the courts said very clearly that it will make its decision on the 21st, and we should all await that date. I see final pronouncements being posted around the Facebook as though, this is the end all. This is simply a conservatory order until the main event comes and is concluded.
If you come April 31st, legally, with your legal background, what are the expectations regardless of what decision the court makes?
Look, I am of the firm view that the appeal has no likelihood of success. I will prosecute that position. I will articulate that position before the court. We will articulate that position, and I hope that we will prevail. I am confident that we will prevail because, as I have been saying, it cannot be the law of extradition that one can concoct a claim of bias against the government on the basis of political rivalry, and that prohibits the government from discharging the legal obligations that devolves upon the government under the law of extradition. Extradition can never become, rather political rivalry and political contestations can never become a safe refuge for extradition. And that has been my position from the beginning. If that is so, then every potential extraditee simply has to enter politics, and that's the end of the matter. That is not the law.
This matter has been faced with a series of delays. Is this normal in these proceedings?
It is not, and you know, I'm glad that you asked me that question, because the CCJ president asked that question. And I answered to say that most of the extraditions that we have done in Guyana are done in the way whereby the fugitive offender surrenders. And based upon my recollection, the few that have been contested, they have been concluded swiftly, with no prolongation of evidence taking in the committal hearings, because it's a bundle of documents that are the crucial aspect of the case, not who received it and matters ancillary to and extraneous to the bundle. It is the bundle that you have to examine to see whether the offense is an extraditable offense, whether the documents are properly authenticated, and whether there is a threshold of evidence. It's as simple as that. Everything is in the bundle. It matters not who received the bundle and who they are related to and how many papers are in the bundle and the quality of the paper in the bundle. The bundle didn't come from Guyana, and that is why the law of extradition says that it is based upon comity. You have to accept to a certain level the processes of other countries. These documents are indictments from a court in the US. A court of Guyana is expected to treat them with a certain degree of comity and respect. The other set of documents come from high governmental officials of the United States of America. The government of Guyana reciprocally is entitled and required to treat the documents under the hand of those office holders with mutual and reciprocal respect that we will expect our documents to be treated with in a similar extradition environment if the process is reversed, because extradition is a mutual process. It's a reciprocal process.
Thank you so much.
You're welcome.